The roster for today's deliberation is the custodial torture or the ramifications of custody. I must make it clear that there are n number of competent and conscientious personnel referred to in this presentation who are doing their might to preserve the law and order in the society and who are also rendering their services exceptionally well in the COVID situation. Having said that, I also make it a duty to indicate that the facts, figures, and observations to be made hereinafter are not directed at any particular individual or institution. Friends, governance in a country with a population of about 135 crores is a tough roster, particularly with an undeniable legacy of subjugation, colonial subjugation for over a century. Be that as it may, I would focus on the roster for today. A recent episode involving the life of a father and son in Tamil Nadu, allegedly due to custodial torture, brings to the fore the need for putting in place a mechanism that like incidents do not occur in our society. And in case an incident occurs, legal accountability is fixed and the wrongdoer brought to book and punished as per the law of the land. Sub judice rigor would forbid any further elaboration. The apex court, being the repository of faith of the protection of fundamental rights of the citizens, has always been innovating in order to be able to safeguard the rights and liberty of the entitled. D.K. Basu's case is a classical example in that case. You see, the executive chairman, Declared Services, a non-political organization registered under the Societies Registration Act, addressed a letter in the month of August 1986 inviting the attention of the then CJI, Justice P.N. Bhagwati, to a news item appearing in the Telegraph, a newspaper, and also another issue dated somewhere in August 1986 of the Statesman. The news items were regarding deaths in police lockups and custody. The author of the letter pointed out that it was imperative to examine the issue in depth and to develop custodial jurisprudence, formulate modalities for awarding compensation to the victim, family of the victim, for atrocities and death caused in police custody, and to provide for accountability of the efforts made to hush up the matter of lockup death. On the request of the author of the letter, it was treated as a writ petition and notice issued to the respondents. By way of a reply, hushing up was denied and action taken against the guilty was avowed. The writ petition was described to be misconceived and malicious. As luck would have it, during the pendency of the writ petition, one Ashok Kumar Johari addressed a letter to the then CJI about the death of one Mahesh Bihari of Pilkhani, Aligarh, in police custody. That letter too was treated as a writ petition. Thereupon, the apex court ordered the issuance of notice to all the states to have their say if they wished to. A notice was ordered to be issued to the Law Commission as well for suggestions. An affidavit was filed by about half a dozen states, including West Bengal, UP, Madhya Pradesh, and Haryana. The Union Territory of Chandigarh and Law Commission too filed affidavits. Inexplicably enough, the other states did not file affidavits. An amicus curiae, Dr. A.M. Singhvi, was appointed by the court to assist it. The Law Commission suggested the incorporation of Section 114A of the Indian Evidence Act. The Apex Court gave a number of directions, 11 in number, which I may like to enumerate here. An arrested person has the right to meet his lawyer. He has the right to medical examination every 48 hours. The arresting officer has to inform a relation regarding the arrest of the arrestee. The number of mobile on which the communication is sent has to be provided by the arrestee and noticed in the memo of arrest. If there is no mobile number, information regarding the arrest has to be given to the local legal service authorities of the district in which the arrest is made. The arrestee has to produce before a magistrate within 24 hours. The arresting officer has to prepare a memo of arrest, which must be attested by at least one witness. The arrest has to be entered in the daily diary register and also communicated to the control room at the district headquarters of the concerned district and all the district headquarters and also the state headquarters. The award memo has to be forwarded to the Ilaka magistrate also. The arresting officer must, at the time of the arrest, carry clear identification of his name and designation. The Apex Court gave those directions which had to be followed up by all the courts and the police authorities. The Apex Court also gave a very interesting direction, which was very relevant. There were a certain number of states which did not have a Human Rights Commission in place. The Apex Court said that the Chief Justice of the concerned High Court, having territorial jurisdiction in that state, would appoint a Human Rights Committee which would be headed by a sitting judge of the High Court and which will have 2 members, preferably of the rank of district judges. The Apex Court further held that the prisoners under trials and detainees are not denuded of their fundamental rights under Article 21 of the Constitution of India, and it is only restrictions permissible in law which can be imposed on the exercise of those rights. After the judgment in A.D.N. Jabalpur's case, it was very particular and pertinent for the Apex Court to say that the fundamental rights do not stand eclipsed. The arrestee continues to have access to the fundamental rights. Yes, in terms of the Code of Criminal Procedure, which provides for the manner in which the arrest has to be made and the arrestee has to be treated, interrogated. The restrictions permissible under the law would indeed be applicable to the exercise of fundamental rights, but there will be no total and unconditional eclipsement of those fundamental rights. Friends, here I would like to bring to your notice a case, State versus Shyam Sundar Trivedi and others. It was a case in which one Nathu Banjara died in police custody. The police version was that he had been interrogated and let off, and he died thereafter. They did not claim liability for his death. A passerby, as per the information available, found him struggling for life by the roadside, and he reported his death to the police. See the anomaly of the situation. On the basis of the evidence adduced at the trial, the accused got away up to the High Court. However, the tables turned against them in the Apex Court, which came down very heavily upon the quality of appreciation of evidence up to the High Court. It agreed that the state interest and the individual liberty must coexist and have to be taken care of simultaneously. Interrogation is all right, but torture cannot be allowed. Torture in custody. The Apex Court made certain observations which I would like to quote. Quote, from our independent analysis of the materials of record, we find that the trial court and the high court, if we may say so with respect, exhibited a total lack of sensitivity and a could not care less attitude in appreciating the evidence on record, and thereby condoning the barbarous third degree methods which are still being used at some police stations, despite being illegal. The exaggerated adherence to and insistence upon the establishment of proof beyond every reasonable doubt by the prosecution, ignoring the ground realities, the fact situations, and the peculiar circumstances of the given case, as in the present case, often results in miscarriage of justice and makes the justice delivery system a suspect. That judgment was delivered by the Apex Court on 9th May 1995. The basic rationale recorded very ably by the Apex Court was that while appreciating evidence, the courts must not forget that there would hardly be any eyewitness available in a custodial torture. If a police official were to indulge in custodial torture, he would ensure that no evidence is left to prove the commission of the crime. It is not to suggest that a trial court would proceed to record conviction just on the basis of the nature of the crime. No, there has to be evidence to connect the persons in charge of the custody with the crime and with the loss of life of the arrestee. I would give you two other examples nearer home. In the state of Haryana, district of Rewari, a person died. The police laid the blame at the door of his wife and daughter. They were taken into custody. The police version was that the deceased was unhappy with the wayward way of life of his wife and he committed suicide. Or they forced him to commit suicide. The mother and daughter were in police custody. The police officials misbehaved with them. The mother got apprehensive that during the coming night they might not be treated fairly by the police. She sent her daughter home on the pretext of collecting wearing apparel for the night. She brought along sulfurous tablets. Both the mother and daughter consumed those tablets and died. One of them died instantly, while the other died after having made a dying declaration about the facts to a deputy superintendent of police and an executive magistrate as well. I understand that the police officials concerned were tried in a trial court and the living accused, some of them had died in the meantime, they were convicted by the special judge CBI court at Ambala. There was yet another case where a person had been summoned by the police of a police station in the district of Rewari for interrogation. It was found in the morning that he had been emasculated. The police put up a version that it was a self-induced emasculation. The police officials were acquitted by the trial court. In appeal against reversal, and I was a party to that TP, we reversed the finding and held that no, it was not a case of self-inflicted injury, but emasculation had been foisted upon the man. My only purpose of narrating the particular instances is to indicate that there would hardly be any evidence available to the custodial torture. But then the concerned supervisory officers and the magistrate, they owe a duty to the law and to their functioning that they must ensure that the mandates provided in the D.K. Basu's case are complied with. The supervisory officer, which is normally of the rank of a deputy superintendent of police, must ensure by perusal of the case diary that the relation of the arrestee had been informed, that the arrestee had been medically examined, that there were no injuries found on medical examination on his person. Then, when the challan is forwarded to the public prosecutor for checking, he must also ensure that all these mandates of the apex court in D.K. Basu's case had been complied with. Then the role starts of the Ilaka magistrates. He must dutifully peruse the memo of arrest, sign it, and ensure that the medical examination had been conducted, that a relation of the arrestee had been informed of the arrest, and the other instructions of the apex court on the judicial side had been complied with. As I feel, the Human Rights Commission of the state also has a duty to perform in this context. It should see to it that the instructions with regard to the notification of people in custody had been complied with by being put on the notice board of the concerned district, all the districts in the state, and the state headquarters. And it might very well consider conducting periodic inspections, surprise inspections, to see that there are no people unlawfully detained in the police stations. My friends, what I wish to say is, know your rights, protect your rights, respect the rights of others, respect the law, comply with the law, and make the society a better place to live. Police people must interrogate. Interrogation is a part of the process on the basis of which they would make their submissions before the trial court. But torture ought to be foreign to the system of interrogation. Jai Hind.